to coming with such a wide range of expertise. Both in your written evidence and in your oral evidence, you referred to the YJB developing guidance to help all secure establishments plan and implement restraint minimisation strategies. Yet we heard the other day, certainly Baroness Linklater and I heard, that there remains available a technique of restraint that has not been used since 2007, but yet it remains available. If it's not been used since 2007, why is that technique still kept available?
I'm not specifically aware of which technique you're referring to, sir.
Well, somebody else will have to tell me the name of the technique, but this the double, yes, double embrace.
The double-seated embrace
has
definitely been withdrawn.
Definitely being withdrawn.
Double-seated embrace.
And when is it being withdrawn? Because we were not told that by your chairman.
It was withdrawn some time ago.
We're not talking about that. We were told the other day by your chair, Mr. Doan, that there is one technique still available which has not been used for a number of years, and she was questioned on that occasion as to why it has not been withdrawn if it's not really used. And I would simply ask you to have a look at that, and if you wouldn't mind, just respond on that point at a later stage.
I'd be delighted to. And as all sensible chief executives, I don't disagree with my chair without being sure of my ground.
A completely different question. Mr. Williamson and Mr. Smallridge made 58 recommendations, of which 56 were accepted 4 years ago. Why are as many as a third of them still not implemented?
I think we're making progress across the board. I know we didn't submit because the length of time, the length of space available for our submission was slightly prescribed, but I'd be very happy to send you a detailed note of the progress in relation to all the recommendations that were accepted. I can't immediately identify a recommendation over which progress has not been made. Quite often the issue around implementation has been about taking our providers and staff with us. It's never as simple as simply declaring it shall be so and imagining that immediately practice changes. And that would explain, I think, in some instances, why we go at the pace we do. I can give you an example of that, which is this issue of full searching. It's been the YJB's position for some time now that the most appropriate approach to full searching is that it should only be commissioned on the basis of the risk assessment. In other words, there should be an identified reason to search fully a child or young person in a secure state. Now, some of our providers are already there. Indeed, it was already their practice. So, for example, before the YJB took the position that it did in relation to that, I know it was the practice in the YY at Park, run for us by G4S, that there would be no longer full searching on a random basis, but it would be based on risk assessment. We're currently in discussion with NOMS, which is the main provider, where there still are full searching, not just on a risk assessment basis, about how quickly they can move to introduce a system of risk-based full searching.
Can you assure us that full searching does not take place on a routine basis in any institution after visits? Because I have certainly had evidence placed in front of me suggesting that in some institutions that still does occur.
I hand over to my colleague Ray Hill.
Yes, Mr. Hill.
Yeah, I mean, it shouldn't be the case, although we were informed following a visit by the Deputy Children's Commissioner of that practice within a secure training centre. Immediately the YJB informed that provider that it must stop. So it's not to say it hasn't happened, but simply the YJB is on top of it and it has ceased to date.
When did it cease?
We informed it would be in Hassockfield STC around about September 2010.
Given that the Howard League's report, which was an entirely private report, obviously not a statutory document, but also the independent review of restraint, the IRR report, took place in 2007, why was this practice still continuing 3 years later when it was absolutely clear to everyone that the routine searching of children in institutions without a proper risk assessment was not only unacceptable but damaging?
Well, I might start with that, and then I'll hand over to Ray as well. Firstly, just in terms of the chronology, the independent review of estate began in 2007, but the report wasn't actually published until the tail end of 2008, and so that does actually slightly shorten the timescale on which you're talking about. But it does go back as well to my point around implementation. Not all of these issues are as straightforward as simply there being a recommendation this shall happen and being able to decree that it should happen, and it then practice changes overnight. There are reasons why these practices have existed in the past, and actually if what you're concerned to do, as we are, is to fundamentally change practice, you have to go at the same pace as your provider to a degree, in terms of listening to what they're saying about what they will need, perhaps in terms of additional resources, in terms of training for staff or whatever. And that would apply across the panoply of recommendations from the IRL. So that would be an explanation as to why things have not moved perhaps as quickly as you would like, and I'd add, as quickly as we would like.
But can we take it, and this may be very helpful evidence on your part, that it is now accepted that just as routine searching of adult women in prison has stopped, by the same token, routine searching in any circumstances of children in prison has stopped?
No, we're engaged in a discussion with NOMS about how quickly they can move to that position. Do you want to elaborate?
I mean, we've been in dialogue with the NOMS policy group, and the Young People's Team referenced this. We've agreed in principle the approach, but the formal process now needs to go for what's called the operational policy group at NOMS, where we expect what's been agreed at this level to be ratified and then implemented.
And what's the timescale for this process?
I understand the meeting with the operational policy group is next week.
So we can expect a decision next week and a protocol when?
I would expect we would talk through the arrangements for moving to the new systems within a couple of months of that.
And given your timetable, we'll send you an additional note on that. So at the time that you come to write your recommendations, we'll give you an up-to-date piece of information.
Can you tell us now a little bit more about the role of, well, you haven't said anything about it yet, it's in your written evidence. Can you tell us something about the role of monitors in monitoring the use of restraint in STCs?
I can. As you know, we have a resident monitor, an assistant monitor, in each of the STCs, and in addition we deploy a number of monitors who visit STCs on a frequency which is dictated, amongst other things, the circumstances of the particular STC at the time. The assistant monitor looks at all reports of restraint, and reports have to be filed with the assistant monitor within 24 hours of the incident. And off the back of that, a proportion of those are examined in detail, and a proportion of all the CCT evidence is examined in detail. All of this information is then distilled into a meeting that takes place on a monthly basis between the governor and the monitor, at which they discuss not just the issue of restraint, but discuss trends in respect